Hello, my name is Steve Lewicki, and I'm a partner at Lewicki O'Connor Hunt & Miser, a full-service law firm in Howard County, Maryland. It's common for clients to ask me whether they're victims of fraud, either in a business transaction or in personal or family matters. Our firm regularly represents clients in those types of claims. The law of fraud in Maryland is complicated. It has unique rules for pleading and proving a claim, and complex issues related to the measurement of damages. This video is not long enough to fully cover all of those issues, but I'd like to briefly discuss some of the key points relevant to fraud claims. Fraud is also sometimes called intentional misrepresentation or deceit. In this video, I'm only speaking about civil lawsuits that assert claims for fraud, and not criminal prosecutions for fraud. There are crimes arising from fraudulent conduct, but that's a separate and also complicated area of the law. A civil lawsuit claiming fraud offers a remedy to someone who has been intentionally deceived by another's representations about the existence of or the absence of a material fact, whether that person relies on the false representation, was justified in doing so, and is actually damaged by doing so. It only constitutes fraud if the person making the representation knew that the representation was false, or made the representation with reckless disregard for the truth. A critical element of a lawsuit for fraud in Maryland is to prove that the defendant intended to deceive the plaintiff. This is referred to as the scienter requirement for fraud. The false representation involved in a fraud claim can be an affirmative misrepresentation of fact, or the concealment of a fact, or a partially misleading disclosure of fact, or even non-disclosure of fact if there was an affirmative duty on the person to disclose that fact. Fraud generally does not encompass statements of mere opinion or promises that amount only to predictions of future conduct or events. A statement of opinion or a prediction might provide the basis for a fraud claim if the defendant possessed special information or qualifications that enhance the credibility of their statement. When bringing a lawsuit for fraud in Maryland, a plaintiff is required to state in the complaint specific facts supporting each allegation of fraud. This is known as the requirement to plead fraud with particularity, and it's a higher standard for pleading than in other types of lawsuits. Another thing that distinguishes fraud from other types of lawsuits is that the plaintiff in a fraud lawsuit must prove each of the elements of fraud by clear and convincing evidence. This is a higher standard of proof than the preponderance of evidence standard that applies in most civil lawsuits. In cases where a person discovers that he's been induced into a contract by fraud, that person can choose between two available remedies: either to rescind the contract and have the parties placed back in their positions held before the contract was signed, or to ratify the contract and seek monetary damages for the fraud. To seek rescission, the plaintiff is required to promptly ask for rescission upon discovery of the fraud, and then to tender back the benefits received under the contract. There are several complicated issues related to the measurement of damages in a fraud case, with courts having flexibility to award damages based on the circumstances. The assessment of damages in a fraud case may include measuring how much was lost out of pocket due to the fraud, or sometimes by a benefit of the bargain measurement. Damages for fraud even can include compensation for emotional distress, but only if the distress is reflected in some kind of manifestation that's physically shown by the claimant. Although a claim of fraud may sometimes be based on improper concealment of a fact, when it comes to business relationships, courts have struggled to determine what level of concealment constitutes fraud and under what circumstances. Typically, businesses engaged in an arm's-length commercial transaction are not in the type of confidential relationship that can support a claim of fraud based on concealment. There could be exceptions to that general observation, however, if the parties on either side of the transaction also have a separate confidential relationship distinct from their business roles. Beyond classic fraud, there is so-called constructive fraud, which arises when a defendant owes an equitable duty to a plaintiff because they're in a confidential relationship, such as between attorney and client, or between a guardian and a ward. As with classic fraud, clear and convincing proof is required to prove constructive fraud. I also want to mention that even when an intention to deceive is not present, Maryland law also provides a cause of action for negligent misrepresentation when someone makes a material representation in a way that is sufficiently careless and that misrepresentation results in monetary damages, but the conduct itself doesn't rise to the level of being deliberately fraudulent. Whether a claim for negligent misrepresentation is available can sometimes depend on whether there's a contract between the parties, or at least the risk of economic loss. The measurement of damages can also vary depending on whether the risk of failure to exercise due care gave rise to a threat of serious personal injury. The broad theme here is that successfully proving fraud can be complicated, and the brief discussion in this video doesn't fully cover all aspects of the subject. If you believe you may have been the victim of fraud, or if you or your company is being accused of committing fraud, I encourage you to promptly consult with an attorney who is knowledgeable about this area of the law. There may be time limitations on asserting any claim. Our firm has the experience and resources to assist you in all of these matters.